I was really concerned by the NDAA that recently passed, that's signed into law. I mean, you look back, Magna Carta 800 years ago, it says, no free man shall be taken or imprisoned, nor will we pass upon him or condemn him, but by lawful judgment of his peers. But this law allows for the indefinite detention of two persons, including U.S. citizens. And you helped craft this legislation and voted in favor of it correctly?
I did. I don't agree with your characterization of what the bill does, however.
The New York Times, the Greenwald, Amnesty International,
Let me take a stab.
ACLU, have all said that this allows for the indefinite detention.
They're wrong. And let me explain why. There is, first of all, no matter who you are, if you're taken, you get habeas corpus. So if you're picked up, you can't be held indefinitely without a hearing. You have to get a hearing for the court. That's something that Bush tried to do. That's why he created Guantanamo. He created Guantanamo because he thought it was outside the U.S. and therefore would see a habeas. But in the Hamdi decision, they said, no, that is effective U.S. control. Everybody gets habeas. Okay, so that's number one. It's completely incorrect. Number two, within the Defense Authorizing Act, one of the things that I fought hard for is specific language that says, and it's right in there, and I urge you to read the sections in question, because I read the New York Times editorial. I have never in my life seen something that was more inaccurate about a piece of legislation. I didn't read the other groups necessarily. And also, I was the one in there lobbying to fix. That was true. Some of that was true in the House version and even the Senate version, but we changed it in conference because of what I was working on. And I am troubled by an aspect of this, which I'll get to in a second. But it specifically says, this shall not apply to U.S. citizens. Lastly, oh no, don't grimace at me. Look at it. It specifically says, this shall not apply to U.S. citizens. Lastly, the portion of it on the authorization for the use of military force is current law. The Obama administration has interpreted the 2001 AUMF to include Taliban-associated forces. All that is in the NDAA is an exact restatement of what the courts have approved and what the Obama administration has argued for. This law, the NDAA, does not expand any of this at all. That is what I made absolutely certain of. Now, where there is still a problem, existing law, I think, is a problem. Existing law is not clear enough on making sure that indefinite detention is not available. Now, you get habeas, but even beyond habeas, I think there should be more limits on when you can indefinitely detain anyone, frankly, U.S. citizen or otherwise. But what is wrong, what is completely wrong in all of this analysis, is that this bill created the problem. It did not. The Obama administration and the courts have upheld everything in this prior to this. Now, it was the opinion of Senator Levin, most strongly, and also Chairman McKeon on the House side, that Congress should speak on this issue. I did not actually agree with them and argued that both of these sections should be stripped out of it and we shouldn't deal with it. But they wanted Congress to have a voice in it. Well, if Congress was going to have a voice in it, I wanted to make sure that it did not expand the authority of the executive beyond where it's at. And that is what we accomplished. Now, I have read everything that's been written about this. It simply isn't the case that the NDAA created this. I read that New York Times editorial, and I understand they were angry at somebody, but what they wrote was absolutely 100% incorrect. And I would urge you to read the sections of the bill that are in there.
In section 21, it says, in section 21, it says, the details in this section only don't apply to U.S. citizens. But section 1022, it makes no provision for that. It talks about a narrower group.
You've got that inverted, actually.
I don't think so.
No, I'm agreeing with you, but it's 1022 that's the military
And also,
custody section.
in the law language of it, it says the disposition of the person under the law of war, as described by subsection A, may include the following: detention under law without trial until
That's
the
current
end of
law.
hostilities.
That's
That is the
current
end
law.
of hostilities.
I have a big problem with that. That's current law. This did not expand what the Obama administration and the courts have said current law is. That's the section that was not expanded. The second section, which has to do with military custody in the US, is the section that says specifically, military custody in the US shall not apply to US citizens or lawful resident aliens. That is
We're
correct.
not required to.
No. It says specifically, this does not apply to US citizens or lawful resident aliens. So part of what I argue is that isn't in current law. So now we have legislative intent that says US citizens, lawful resident aliens should never be subject to indefinite detention, which we don't have before the NDAA.
And while it doesn't expand powers, it's codifying what we consider the exaggerated claims of the Bush administration as to who falls under the 2001 AUMF. In the AUMF, it talks about persons only involved with 9/11.
By the way, I want to point out that in your first sentence that you disagreed with me. Now, you're saying that it's still a problem, but what you had said earlier was that I was wrong, and now you're saying, okay, it doesn't change it, but it codifies it. So,
It's it's also expanding the group. In the first AUMF, it only talks about persons involved with 9/11. Osama bin Laden's dead, and all of these leaders are dead,
Sure.
and yet so it's expanded
But
to.
We need to move.
I want to make
along.
one final point. The NDAA is not what expanded it. The Obama administration and the courts
Expanded their
that-
interpretation.
Yes, they did. They absolutely did. That's what was done, and that's why it was put in there to be exactly the law. Look, as I said, I didn't want either of these sections in the bill, and I argued very strenuously against that. Not
Could
being
you
able
have voted
to.
against it if you had a problem with it?
I had a problem with it if it was expanded. Went from, okay, I wish it wasn't in here at all, to, okay, at least we haven't expanded it. And then there's a whole lot of other stuff in that bill that I didn't want to see go down for the sake of something that doesn't change current law.
If it went down, wouldn't they have
Richard,
brought it up?
Richard, we need to move on.
Okay.
I don't know.